All rise. The Honorables, the presiding judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning. Welcome to the North Carolina Court of Appeals. By way of introductions, I am Jeff Carpenter. I'm your head of the panel. To my right is Judge Fred Gore, and to my left is Judge Chris Freeman. We are fortunate today to have the clerk of the North Carolina Court of Appeals in the courtroom with us, and Tom Salou is our marshal. The case for oral arguments this morning is Duke Energy LLC versus Kiser. It's Court of Appeals file number 25388. The parties ready to proceed?
Yes, Your Honor.
Yep.
May it please the court, David Redding for the appellants, to reserve 5 minutes of rebuttal time. This dispute between Duke Power and my clients, the Kiser defendants, goes back to 2015 when Mr. Michael Kiser built a retaining wall onto property that he contended his father owned at the time, which was underneath Lake Norman. It was done during a period of low water when the ground beneath it was exposed. He constructed a retaining wall and backfilled it some 17 and a half feet away from the edge of his boundary.
Let me ask you a few background questions, procedure-wise. Is it your position that this is the first final order in the case?
Yes, it is.
Okay. In regards to the easement, what is the Kiser's position? I was reading through some of the documentation in the instrument itself, and it appears as though the easement is up to 770 feet above mean sea level, but then there's a meets and bounds. Are the two the same?
They're not the same.
Which easement was granted, or was there two?
So it is a long-standing problem because at the time that Lake Norman was impounded by the Cowens Ford Dam, the surveying methods were not as accurate as they are today. So there's often places you'll find in surveys along Lake Norman where the meets and bounds survey is not exactly the same as the 770 line. But it would be, under surveying law, it would be the 770 line that's actually controlling because it's a natural monument. So we would say that it's actually the 770 line and not the meets and bounds survey that would be controlling.
Okay.
Now, this retaining wall that was constructed at the time indicated the 280 or so acres below Lake Norman where the retaining wall was constructed were at the time owned by Michael Kiser's father, Jack Kiser. About a year later, Jack Kiser passed away, left that 280 acre parcel to his sons, including Michael, and they conveyed it into what became Sunset Keys, which is the other defendant in the matter. So that's why that's there. So as of 2016, it was Mr. Kiser's position that he had constructed a retaining wall on land that he had owned and had the right to do so. Duke Power took the contrary position, instructed him to remove the wall. He declined to do so, and Duke Power filed a lawsuit.
The Kiser's position, as I understand it, is that they own the fee, and Duke has an easement over the fee for the purpose of flooding the pond. Is that the Kiser's position?
Yes, sir. It was at the time.
What is it now?
Well, now it's what the Supreme Court has said it is, which is that the Kiser defendants and Sunset Keys enjoy no property interest whatsoever in the property, that Duke has entire right, title, and interest in it.
My reading of the Supreme Court opinion was that it was a pretty wholesale granting of an easement to use however they wanted to, but I didn't read the Supreme Court opinion to say that, no, this was actually a grant in fee.
That is true.
Do you read it differently?
I do read it differently, Your Honor.
Okay.
Because the underlying summary judgment granted to Duke Power divested the Kisers and Sunset Keys of any right, title, and interest they had in the property. So the order was overreaching, which is one of the things we argued at the Supreme Court level. That what had actually happened was that Duke had retained entire control over the lake bed. So it doesn't say that in the Supreme Court opinion. I agree with that, but that's the practical application.
So obtaining, it's a bundle of sticks, right? Retaining entire control is different than owning all the six sticks which create the fee. Is it your position that Duke now owns all the sticks and owns the fee?
They got all the sticks. That's the precise argument I made at the Supreme
Okay.
Court level, is that if they overturned this court, because this court unanimously went the other way and overturned the trial court, if they overturn this court, that what they've done is extinguish the difference between an easement and fee simple, because it would have given Duke the right, and the main thing we were arguing is Duke did not have the right to convey to third parties the right to place docks and other structures onto the parcel.
Let me read you the holding from the Supreme Court case. It says, in summary, the plain language of the easement is unambiguous and grants Duke broad authority to treat the submerged easement property in any manner Duke deems necessary or desirable. You read that to mean that Duke now owns it in fee simple.
I read it that way. Yes, I do read it that way, but also, again, it's because the underlying summary judgment that they upheld, the underlying summary judgment grants Duke that right and specifically says that Kiser has no more property interest. So that's the practical effect. Agree that the Supreme Court ruling, the holding does not specify that, but that's the practical effect of it.
So counsel, would you argue that even though that's the practical effect, there is some arguable difference in how the court left that to be implemented? So the underlying summary judgment applies it as you've described, but as this held by the Supreme Court could be applied differently by another court technically.
I'm trying to think of an application where Kiser and or Sunset Keys could exert some sort of ownership interest in the 280-acre parcel beneath the lake, and I cannot divine one that they could underneath the Supreme Court judgment. I think the Kisers have no more interest as a result of that. Now, after Duke filed its initial complaint in the Catawba County Supreme Court, claiming that Kisers were infringing upon their easement rights by having constructed the wall, Kiser filed counterclaims against Duke and also third-party claims against the third-party owners who now had docks and other structures on the 280-acre parcel owned by Sunset Keys. So essentially, you've got two parallel claims in Catawba County at the same time. The matter was designated as a 2.1 matter before Judge Poovey at some point in time, and the first summary judgment, the 2018 summary judgment motion was made on Duke's claim, and the court granted that, and that was in 2018. That was not
It was a partial summary judgment.
partial summary judgment, not certified under Rule 54B, so not appealable at the time. Duke made a motion to enforce that summary judgment. What the court had determined in the summary judgment was that Kiser had to take down the wall, had to file an application, an excavation permit with Duke to do so, and had to restore basically the shoreline to its initial where it had been before the wall had gone in. While Kiser was going through that application process, Duke took the position that Kiser also had to pay a $2,500 fee to do so, because that's in their basic application when someone wants to do something. They ask Duke to do something. Of course, this is Kiser being ordered to do it. And that $2,500 was not in the partial summary judgment.
It's kind of why I was asking the questions before. As I understand Duke's position, the Kisers needed to pay the fee and get permission to do whatever they wanted to do, even though, based on the documents in the public registry, the Kisers owned a fee simple and there was an easement. But your position is that Duke actually owns a fee simple now.
Well, after what the Supreme Court has done, as a practical consequence of what the Supreme Court has done. So it's a little bit of a difficult question for me to answer because the Supreme Court didn't specifically say that, but if Kiser were to do something within what it claims would be its continued fee, absent the one stick on the easement, I believe Duke would oppose that. Say, you know, we own it in entirety. Maybe put words in their mouth, but I think they would. So the other thing that Duke required Kiser to do to remove his own wall was to execute what they called a user agreement. And the problem with the user agreement, which is not mentioned in the summary judgment order at all, is it required Kiser to state and sign a document where he said he believed and accepted the fact that any proposed excavation had to be done only on Duke's authority, that an excavation exceeding 2,000 cubic yards required Duke's approval, that Duke can remove a non-compliant structure, and that Kiser's use of his land could not hinder public use. All of those, and those are one of several admissions that were required under that user agreement, which is in the record at page 173. Several of those requirements went directly to the heart of our counterclaims and our third-party claims. And I would not have been surprised to have my friend or his predecessor come to court and say, you waived that. So we entered into negotiations over that, and our position, of course, was that we don't have to do that because the court didn't order that and declined to do it. Ultimately, Duke went back to the trial court and sought an enforcement order saying that Kiser had not done what he was supposed to do. And the court said, okay, I'm going to allow Duke to remove the wall. And Kiser's instructed to allow him to do that.
So is it the Kiser's position that Judge Poovey entered an order based on the scope of the easement? Is it based on the user agreement issue? What is Kiser's position as to Judge Poovey's order appears to me to be based on the scope of the easement, but tell me what Kiser's position is.
If you're, Your Honor, if you're asking me about the initial trespass summary judgment, that's on the scope of the easement. If you're asking me about
So here's why it's important. In order to get to the cost thing, we kind of have to flesh out the underlying stuff that gives rise to the cost, right?
True. And there are a series of interlocutory orders along the way, many, only some of which are in the record, many, leading up to the final order judgment, depending on what you call it, of costs in November of 2024. So the first summary judgment is based on the scope of the easement. That's the 2018. Scope of the easement at record 106, because nobody had asked to remove the wall yet. Now, the enforcement order at record 279, which is November of 2019, that's based on the court's determination that Kiser had not met the application requirements that Duke set out. And we had a dispute about that, and I argued that at the trial court level in that hearing, that he was not obligated to pay that fee, nor would he or could he execute a document where he has to swear and affirm that he's waiving his rights to contend that he has authority over the land. So, in the interim, the very next thing that happens in this case is actually the second summary judgment order, which is also interlocutory. And this is January of 2020. And this is the summary judgment Judge Poovey granted against my client, against him on his counterclaims and his third-party claims. And that was certified under Rule 54B. So we have right now we have two interlocutory summary judgments. Neither of them are final. Only one of them, that's the second one, is certified for appeal, and that's the one we took up because it was certified for appeal. We did not take up the 2018 because it's clearly interlocutory and partial. In the interim, while that was running its course, going first to this court and then to the Supreme Court, Duke made its motion for judgment for cost. So Duke goes out, takes down the wall, does it in a way that we ultimately contend was unnecessary and unreasonable. And the main reason is because they did it from the water side using barges, which was incredibly expensive, rather than going on to Kiser's land and doing it. So they make a motion for costs in that, arising from that in 2020, and that's at record 320. We file affidavits in opposition to that motion, and that's at record 441, setting forth that Kiser is a retaining wall designer. That's his job. That's what he does. He designs and certifies the construction of retaining walls. So he has the expertise to have done this. And he says the cost should have been $9,500. Included in that is an affidavit from a contractor who says he'll do the removal for $9,500. The big distinction between the two is doing it from the seaside, or doing it from the water side, rather. That's where the majority of the Duke costs are. That comes on for a hearing before Judge Poovey, and Judge Poovey decides to stay it because the appeal of the other order is still ongoing. So that hasn't been decided. Specifically, he said that the outcome of that appeal might have an effect or delay Duke's entitlement to award of costs. So as of 2020, Duke's motion to be paid for its costs, or an award for its costs, is stayed pending the final outcome. Now, ultimately, this court's overturned by the Supreme Court. We petitioned for certiorari to the Supreme Court of the United States, and that was denied. Now we're back down in front of Judge Poovey in the trial court and rehearing Duke's initial motion for judgment on costs was filed 4 years earlier. During that hearing, Judge Poovey took note of the affidavits on both sides and ruled that the $76,253 that Duke contended had incurred in expenses was reasonable and necessary under the circumstances. And our contention in this appeal is that ruling is so arbitrary that it could not have been the result of a reasoned decision. And the main piece of evidence I'd point to for that contention is in the transcript itself. And I want to read that verbatim so I don't characterize it because it's so important. In making his ruling, Judge Poovey stated, and this is page 42, line 18 of the transcript, "I think they came back," meaning Duke, "and they said, hey, Kiser, he's kind of said, I don't come on our land, and so had they come on the land, like you say, that's me, they should have, instead of using these big barges, this would have been another lawsuit. He, meaning Kiser, would have been, he would have complained about them ruining his septic tank, tearing up his yard. What did they do? I mean, all that sort of thing is the reason why they did what they did. It's because they know what sort of person they were dealing with. I think everything they did was reasonable. I'm going to rule." Now, there's several things that I contend about that declaration by the court that show that it was abuse of discretion. Number one, he's declining to consider whether or not it was less expensive to remove the wall from the land side because he predicts in the future Kiser might file a lawsuit over it. Well, that's speculation. There's nothing in the record to indicate that would be so. But even if Duke had used the land side, as they should have, because that was a more reasonable and expeditious way to conduct the removal, and they had done damage, it would have been within Kiser's right to do so. He could have filed a lawsuit and said, you tore up my land and you need to pay me for it. So there's nothing pernicious about him doing that, even if it were true.
I'm not sure about that because Duke had an easement to gain access over the lands of Kiser. They had an easement even over the island to gain access to the water. Am I misreading the language of the easement?
So their easement is a flood easement and allows them to flood up to 770, 780, I think, on some circumstances. Also allows them to clear brush and that kind of thing. Whether or not it allows them...
The language of the easement is parties of the first part grant into Duke Power Company the right of ingress, egress over the land herein described, said right to be over such roads as are now or hereafter may be on said land, and in case of there is no road, such land which is suitable for ingress and egress by the power company.
Yeah, well, I'm not denying that they had, in fact, that actually goes to our argument. They had the absolute right to enter the land, and the only time that Kiser ever indicated through counsel that they could not was when we were disputing over the user agreement. At no time after that, after the judge ruled that Duke had the right to self-help, the self-help remedy, we didn't tell them to stop, and they never asked to use the land. They just decided to do it from the water side themselves.
So, counsel, is it your contention that the context of his verbal determination is what you take exception with, and not forecasting? It sounds like what you're getting at, his determination. So let me ask you this: without the judge ever commenting on it, would there be any argument for an abuse of discretion if Duke had just decided to do that and then there was a determination by the court? Would there be any argument for you for abuse of discretion at that point in time?
Sure, I'd be making the same argument, Your Honor. So if there's a $9,000 way to do it and a $72,000 way to do it, and there's got to be some analysis as to why you choose the more expensive way rather than the less expensive way. There's nothing in the order itself that indicates there's no finding in the order of obstreperousness, of litigiousness, or any of the things that would justify using the water side. And in fact, the last thing that Judge Poovey said in this, when he was saying these things, was that that Duke knew the sort of person they were dealing with. So that betrays some sort of animus on the part of Judge Poovey towards Kiser. I'm not sure why.
Isn't it true that the Duke folks gave opportunities to Kiser and communicated therewith to do this on their own? They didn't, installed, and that Duke even took the lowest bids on this work to get it accomplished. Is that accurate?
If you don't mind, Your Honor, I'll answer the second part first because that's easy. We've never contended that they didn't actually spend the money or try to do it from the water side in the cheapest way. That's not a contention that we're making. We are, as to the first part of your question, which I believe is, didn't Duke give Kiser a chance to do it himself? I think that's what you're...
correct. The order told Kiser to do it. Kiser didn't do it, so Duke had to come in and do what basically they didn't do.
If it were that simple, then your decision would be very simple. But after the enforcement order, when Judge Poovey gave Kiser the choice to do it himself, and if he didn't do it himself, that Duke could then exercise self-help. Literally what that order says is that he has to fill out an application. That's what it says. That's it. And there's nothing about this user's agreement or this application fee. So Kiser does, the record does show that Kiser did fill out most of the applications. There's a lot of stuff you had to do. You had to get the Catawba Indian tribe to approve your plan. You had to get Department of Natural Resources to approve it. He did many of these things. But what he didn't do was complete the user agreement and pay the excavation fee. So he tried to avail himself of the option that Judge Poovey gave him to do it himself, tried to do it. And the big stopping point, and I'm sure my friend is going to say there might be other things in there, like they didn't like the plan. That may not be true, but I think it's irrelevant because there was no point in time where my client was going to be willing to waive his rights to pursue his counterclaims and his third-party claims by admitting in a document that he was required to sign that he had no dominion over the land. That's the end result of that user agreement. So to the extent that Duke offered Kiser the opportunity to remove the wall himself, that opportunity came with so many strings that it really was illusory.
Where's the user agreement in the record?
The user agreement appears at record page 173, and it's several pages long, but there's only 4 actual areas that I point to amongst the others that are problematic. And this is where Duke says, you can't, any excavation you can do, you're only going to do it on our authority. I'm paraphrasing that. Excavations exceeding 2,000 cubic yards require Duke's approval. We didn't believe that to be true.
Did the Kisers enter into a user agreement?
No.
Okay.
Declined to do so. And because what it would have done to the counterclaims and third-party claims. And I instructed him not to write it, to sign it, unless he wanted us to be facing in the other side of the case. The fact that he admits, says, we believe that all these things are true, and all of those things in the Duke user agreement go to dominion over the property, exercise of dominion over your property. So we can't, on the one hand, be taking the position that we own the property in fee simple, and they have one stick, and if it's not interfering with one of those sticks, then we have dominion over it, particularly the grant to third parties of the right to put structures on our land. I mean, if we're going to admit they have the right to do that in this document, my friend would have held that up before the Supreme Court, this court, and I would have lost there.
Did the Kisers go through Duke to build some things through the property, the application process? I believe I read in there they did do that on some things, but not on building this wall. Right. But on other things. Why is that?
I think the record does say that at times, particularly Jack Kiser did, the father did, go to Duke to get permission to erect docks. We have never taken the position that Duke doesn't have the right to control where the docks go. So Duke has the right to permit the use of a dock, but does not have the right to permit the use of a dock on Kiser's land. And that includes Kiser. So if Kiser wants, he's got a dock right now. If he
Supreme
wants
Court
to,
decided that issue as to third parties.
as to third parties.
Limited to as to third parties. They didn't decide it as to the Kisers, because the Kisers are in a different position than the third parties. The third parties don't own fee simple interest of record. The Kisers do. That's the difference. I presume that's why they only addressed as to third parties over there.
Well, Your Honor, now you're running into the FERC license. And that's a big part, that was a big part of Duke's argument at every level. And under the FERC license, that Duke has the authority to regulate activities and structures on Lake Norman, which we don't dispute, including the right to put up a dock. And Duke controls where you put the dock up. You know, they figure out the angles. So we don't dispute that. What we dispute is that Duke had the right to say to a third party, a stranger to the Kiser parcel, that they had the right to put it on Kiser's land. They had the permit to do it, but the third party would have to go to Kiser for the right to do it. It's the clash of a regulatory restriction and a property right. Only Kiser had the right to grant someone an easement on his land to put the dock there. So that's where it gets a little confusing. But that power that Duke has to regulate docks extends to the Kisers too. I mean, if they want to put up a dock.
You're in your 5 minutes there.
Okay.
Take as much time as you want. Just
I felt like I finished my answer. I hope I didn't make it more confusing, but I will take the rest of my time in reservation. Thank you, Your Honor.
thank you. For the appellee.
Thank you, Your Honor. Good morning. May it please the Court. Joshua Davey of the Troutman Pepper Law Firm here on behalf of the appellee, Duke Energy Carolinas. The Court should dismiss this appeal, or in the alternative, if it does not, it should affirm the trial court's cost order in 2024, which was well within Judge Puvi's discretion. The general statutes governing this court's jurisdiction permit appeals only from certain kinds of orders, final judgments, and second, certain interlocutory orders, most commonly those that affect a substantial right. And if an order doesn't fall within one of those enumerated categories in the statutes, it's not an appealable order, and the 2024 cost order is one of those. First off,
Your position is that Judge Puvi can assess cost and there's no review of that.
not under the facts of this case, Your Honor, and I'll tell you why. First off, it's not a final appealable judgment because it doesn't resolve any claims on the merits as between the Kisers and Duke Energy. Those claims were adjudicated in 2018 and 2020 summary judgment.
But it left open the order, so this is, the Kiser's position is, and I think I agree with him, this is a first final order in the case.
I don't believe it's a final order, Your Honor, because it didn't resolve those claims on the merits.
Help me with that.
Yeah, certainly, Your Honor. So it's well established in the cases, and we cite some, that in order to pay costs by itself is not, it's always analyzed under the substantial rights doctrine, which tells you that the courts don't view those as final orders. And the courts hold that just an order that by itself, in order to pay costs, is not appealable. The statutes, if you read them, that govern this court's appellate jurisdiction, aren't focused on chronology, and the case law interpreting those statutes isn't focused on chronology. It's focused on what does the order do? Does it resolve claims on the merits? And the cost order does not. And for that reason, it's our opinion that it's not a final order. Last in time is not the key thing. What matters is, does it adjudicate the claims on the merits? And I think it's worth recounting a little bit of the history of the case to understand how we got here, to help elucidate this point. So we're here because the Kisers constructed a retaining wall in the lake bed of Lake Norman and backfilled
on
it.
property that they own.
On property that they own and over which Duke had an easement.
Correct.
Yeah.
So you disagree with him. He says Duke owns it in fee now, but I can't see anything where Duke paid for it. You believe that Duke still has the easement that they got from...
It's the easement, Your Honor. That's what the Supreme Court held.
That's how I read it as well.
And when the Kisers did that, the important thing is that when they filled that in, they displaced 50,000 gallons of Lake Norman, enough water to power 100 houses for a month.
What's the gallons of Lake Norman at full pond?
I couldn't tell you the number. It's a big number, Your Honor. It's a big number.
Hundreds of millions.
Hundreds of millions. I think that's fair.
So at the time the wall was put in place, they displaced it at that time, or was it subsequently displaced if it filled back in?
The effect, I think, yeah, the lake had receded some, Your Honor, so I think the effect of where they put the wall was ultimately to displace 50,000 gallons after the lake came back.
Because how you stated it was that they affirmatively displaced it, but as it was placed, they didn't displace any water at that time, correct?
That's a fair distinction, Your Honor. And I didn't mean to suggest that, they had done that on that day.
Yeah.
But the ultimate effect was that that's what had happened. And the main,
If the water came back.
yeah, which it did. And the primary point here, I think, is that construction of the wall was illegal under the FERC license that Duke has from the Federal Energy Regulatory Commission to operate Lake Norman. And part of that license requires Duke to maintain that shoreline and to make sure, and the reason for that is, I think it's important to remember, is that so Duke can fulfill its mission of delivering electricity to its customers at just and reasonable rates.
The Kaisers weren't party to the licensure agreement with the federal government.
No, Your Honor.
Say they displaced 50,000 gallons of water when it comes back at full pond. Where does that 50,000 go?
It would ultimately flow out of the lake. The lake only goes up so high.
It just gets, dam's the same height. It just gets pushed a little further up the river, right?
Well, the water would no longer be there. Yeah.
But the dam's the same height. It didn't decrease.
Dam did not change.
It's gonna, the full pond volume's still the same. It's just where the water sits.
Well, the available volume within the height limit is not the same because you've reduced the amount of storage capacity in the lake.
Then we get into the difference between the 760 feet and then the high water mark of 770. And
where are you? Yeah.
That's contemplated. So your position is that by building this wall, they would have pushed water back, which exceeded the 770, not the 760, which would represent the top of the pond.
Was within Duke's management responsibility under its FERC license. And I think, Your Honor, even if that weren't the case, the Supreme Court had resolved that issue and said Duke had the authority to do what it did here in terms of...
As to third parties.
I think, Your Honor, the Supreme Court's decision holds that the easement covers the retaining wall the Kiser's constructed.
Let me make sure as we go down that discussion, to back up just for a second, ask a question, because it wasn't evident, but it only comes because of Judge Carpenter's question. The Kisers were not a party to the license agreement with the feds. You answered that, no. Is there any discussion in any of the deeds or covenants with the property within this area and contiguous lands purchased, any discussion in deeds or covenants about this licensure agreement with property purchases?
Which deeds and covenants, Your Honor? I'm sorry.
With any purchases of, so say if the father who passed away didn't convey it to Kiser the son, sold it to a third party, and they bought it. Is there any discussion in the deeds or covenants of the transactions of land transactions about this licensure agreement with Duke and the feds as it pertains to the easement that comes with the land?
So, Your Honor, if I understand the court's question, I believe that if the land were transferred to fee simple, there, of course, would be a title search which would flag this easement, which is driven by Duke's FERC license. Yeah. I don't know if the license itself is mentioned in the easement. I'm not certain of that as I stand here today.
That's the specific question. Is there any discussion or disclosure of the licensure in
certainly the easement itself is would be part of any disclosure.
Okay. Mr. Davey, I've got a question for you.
Yes, Your Honor.
It's just because curious minds want to know. At Lake Norman, how many easements does Duke hold over flooded property that they don't own the fee?
Your Honor,
is this the only one?
I don't know that number. I don't think it's in the record.
Yeah, that's not the normal way that these reservoirs are built. Most of the time, the utility company acquires all the property. When I saw this, I said, wow, this is unusual.
Your Honor, that may be, I'm not certain. I don't think there's anything in the record that would tell us what the predominant form was. But I think the point of all this, Your Honor, is that as a result of the construction of the retaining wall, Duke had to file a lawsuit. And then the court, as my colleague mentioned, entered a series of orders, right? First, the 2018 order granting partial summary judgment for Duke, then a 2019 order enforcing the prior order after the Kisers had failed to remove the wall as the court had directed, then a 2020 summary judgment order which disposed of the rest of the claims. At that point, the merits of the claims between Duke and the Kisers had been resolved. And that order, the 2020 order, went up on appeal to the Supreme Court. The 2018 order, the Kisers never perfected an appeal from that order. Then there was the 2020 order in which the trial court, Judge Poovey, agreed that Duke's costs incurred in removing the wall were the $76,000 that Duke has sought and seeks affirmance on appeal. And then finally, the cost order at issue in this appeal entered in November 25, 2024, which enforced those prior orders. And that gets back to our reason why we don't believe that's a final judgment, Your Honors, because it's just an enforcement of the court's prior orders. Now, the other basis, potential
The
basis.
court's prior order didn't fix the cost, though. It just left the door open to be determined at some point in the future. When does the case ever close? Or the enforcement order.
The 2018 order granted Duke a monetary judgment for the amount that it would be required to remove the wall. But you're correct, Your Honor, it did not fix a certain specific sum associated with
It didn't even fix who would. Duke only collects in the event that they use the self-help remedy, right?
That's right. That's right. So the other basis for an appeal to this court is the substantial rights doctrine. And we don't believe that this appeal is properly before the court on that basis either. First off, the Kisers waived any argument that the case could be appealed under substantial rights because they never argued that in their opening brief to this court. It's not in the statement of the basis for appellate review as required by Rule 28b-4 of this court's rules. And that alone is sufficient to warrant dismissal of the appeal on that basis. And that's, I would cite the court to the Larson versus Black Diamond French Truffles case. It's a decision of this court from 2015. It's at 241 NC App 74. And the setup there was procedurally the same as what we have here. The appellant filed an appeal to this court, did not indicate in their opening brief that they were appealing on the basis of substantial rights. The appellee made their arguments, and on reply, the appellant argued that their appeal was proper because it affected a substantial right. And this court said that wasn't sufficient. That issue had to be raised in the opening brief. You can't bring it up in reply and carry your burden as the appellant to establish a basis for appellate jurisdiction. That's the same setup we have here. The Kiser's brief does not argue in the opening brief that this order affects a substantial right. That's only raised in the reply brief, and under Larson, that's insufficient and the appeal should be dismissed. But even if the issue had been preserved, there's no substantial right implicated here. And this gets back to what we were discussing a moment ago, Judge Carpenter, in that an order that orders a party to pay fees or costs is not by itself an order that affects a substantial right. And there's a number of cases we cite in our brief for that proposition. Nor are any of the other bases for interlocutory review applicable. This is not an order that granted a new trial, for example, or denied a new trial, and that's not contended by the Kisers. They cite two cases in their brief. I'll talk about those briefly. They cite the Redden case and argue that that indicates there's a substantial right at issue here because the order involved a requirement to pay a large sum of money. But Redden is readily distinguishable because in Redden what you had was an order that adjudicated at summary judgment some of the claims between the parties and also had a cost award, a fee award associated with that. And on that basis, this court said the order affected a substantial right. And it's worth noting that the Redden appellant indicated in their opening brief that they were appealing on that basis. But neither of those is true in this case. So we don't have a situation where the appellants argued in their opening brief that the appeal was based on substantial rights. And we also don't have a situation where the order being appealed from adjudicated any claims on the merits. The Kisers also cite in their brief a case called Preston, which is an error, I believe, in their brief, because Preston dismissed an appeal from a Rule 11 sanctions order. But there's a case discussed in Preston called Beasley versus Beasley, which I think is the case that they meant to cite, because that's the case that involved a $48,000 attorney fee award that they mentioned in their brief. And the setup in Beasley was the same as in Redden. The underlying trial court order adjudicated claims between the parties on the merits and awarded fees. And on that basis, this court said the order affected a substantial right. But again, as I just explained, that's not the case here. This order doesn't adjudicate any claims between the parties, and the Kisers didn't appeal on that basis. So for those reasons, we would ask the court to dismiss the appeal. It's not a final judgment, and it doesn't impact a substantial right. But even if the case were properly before this court, it fails on the merits because there was no abuse of discretion here. This order was well within Judge Poovey's discretion. And because the specific issues that the Kisers now raise relating to the application fee and the user agreement, and now for the first time in argument this morning, that Judge Poovey had some sort of animus toward Mr. Kiser. Those arguments were not preserved, and they have no merit. So let me talk about that for a minute. First off, there was no abuse of discretion here in the cost award. So our Supreme Court has made very clear that abuse of discretion occurs only if a court's order is, quote, manifestly unsupported by reason, or is so arbitrary that it could not have been the result of a reasoned decision.
So, counsel, let's dissect what was said on the record then.
Yes, Your Honor.
How do you get around the argument by the Kisers that what was said shows some forecasting, or to use a legal term, potential advisory determination by the court and why the court decided to allow to happen with it? How do you get around that argument?
So a few things, Your Honor. Number one, that argument was not made in their briefs, and it's not before the court.
Understood.
Yep. Number two.
Entertaining.
Certainly, Your Honor. Thank you. Certainly. It's not part of Judge Poovey's written order either, and he did say what he said on the record. And I think it's important to remember that Judge Poovey at this point had been presiding over this case for something like 6 years. And he had a lot of familiarity with procedural history. He had a lot of familiarity with the difficulty that Duke had encountered in trying to have the Kisers remove the wall themselves following the 2018 order, and the sequence of events that followed that. And I think his comments really just reflect the reality of the situation, which is that you have a defendant here who built the wall illegally, didn't want to take it down, and then refused to comply with the court's orders despite having multiple chances to do so.
Not disagreeing with that, because obviously as you continue to work on something, you build calluses a little bit. But understanding how his words are arched, there could be an argument that Judge Poovey's peeking under that blind justice for objectivity purposes. Just it's hard to turn a deaf ear to untold that bell once you hear what he said.
Your Honor, I would respectfully disagree with that. I think someone could make that argument, but I think Judge Poovey's orders reflect that he analyzed the issue thoroughly. He considered the evidence in front of him. If you read the transcript of the hearing, he entertained arguments from counsel at length and considered what was in front of him and made a decision based on the evidence presented. And I think that's what the record reflects. Now, let me talk about the evidence that was presented for a minute, because that goes to whether there was an abuse of discretion. So this issue of Duke's costs had been briefed in 2020 when Duke initially sought, after it had removed the wall, sought an award of its costs for doing so. And it submitted at that time affidavits of Chad Broadway and Chris Handy, which are in the record, which detail and itemize Duke's costs incurred in doing the work, including some costs that the Kisers challenge now on appeal, for example, for riprap and for fabric, dumping fees, etc. In response, the Kisers submitted affidavits that were prepared after the work had been done. And they would sort of conclusively say, we think this work could have been done more cheaply. The trial court then heard argument on that in August of 2020. It entered its 2020 order agreeing that Duke's costs were the $76,000 figure, but then staying the issue. And then after the Supreme Court affirmed the 2020 summary judgment ruling, Duke noticed that again for hearing. And that's what led to the November 2024 hearing and the order that we're here about today. And that's the hearing at which Judge Poovey analyzed the evidence, heard arguments of counsel. Now, there's a few arguments made in the briefs, we didn't hear that this morning, about why there was an abuse of discretion. I already talked about one, the comments that Judge Gore was alluding to. Another argument that's made in the briefs is that the court was required to hold an evidentiary hearing. I would submit that's just wrong. The Kisers don't cite any case law to support that proposition. They do cite the Lemon case in their brief, but Lemon actually favors Duke on this one. In the Lemon case, the court held it was within the trial court's discretion whether or not to have an evidentiary hearing, even though there were competing affidavits submitted. And that's consistent also with Rule 43 of the Rules of Evidence, which give the trial court that discretion. In addition to that, at the 2024 hearing, and you can see this in the transcript, the Kisers never made any sort of offer of proof as to what evidence would have been presented had they been able to have an evidentiary hearing. In fact, they never even requested an evidentiary hearing. At the hearing, Duke's counsel indicated that Mr. Broadway and Mr. Handy were present in the courtroom and were prepared to provide testimony if the court wanted to receive it. And at that point, and I'll read to the court from the transcript. It's at page 20, line 25. Mr. Redding, who was there, he stated, quote, "As to witnesses, this is not an evidentiary hearing, so I would object to any witness testimony. I had no notice that there was going to be witness testimony. I'm not prepared to question these witnesses, so I would object to these witnesses testifying. We have their affidavits. We have my client's affidavit." Now, having objected to the presentation of any evidence at the trial court, and having made no offer of proof as to what evidence would have been presented had there been an evidentiary hearing, the Kisers cannot now complain to this court that the trial court elected to resolve the issue on the affidavits presented to it. And we cited cases for that in our briefs. The Kisers also argue that the trial court blindly accepted, that's the phrase they use, Duke's evidence without giving credence to the appellant's evidence. But I think the transcript and the order that Judge Poovey entered reflect that's just not the case. Judge Poovey again heard argument at length, considered the affidavits presented, found that he did not need to have an evidentiary hearing. And
This was a summary judgment. There was a jury trial prayed for. Are these questions of law or questions of fact? When you're comparing the affidavits and weighing the credibility of the witnesses, is that a judge thing as a matter of law, or is that a jury thing?
It's a judge thing. Rule 43 of the Rules of Evidence.
Okay, tell me about that.
Yeah, Rule 43 of the Rules of Evidence is that on a motion, which is what this was for costs, the court has discretion as to whether or not to consider the affidavits or have an evidentiary
Well,
hearing.
this was on the substantive thing where you had the affidavits, right? On the removal of the wall and all the, whether it had violated the easement. I mean, there was.
You're asking in connection with the summary judgment motion?
Yeah, well, I mean, everything builds on, this is the same case. There's no break here. It's the same case that started. It's just now coming to fruition for hopefully the last time here today. I was just looking at some of the old orders. Judge Poovey entered as a matter of, at a summary judgment hearing, he entered judgment in favor of Duke for trespass. The elements of trespass are the plaintiff was in possession of the property. Mm-hmm. That's a hard one to square when someone owns fee simple interest, but they're not the plaintiff. It's you either got to go the trespass route if you're Duke, or you got to go they're overburdening our easement judge route if you're Duke. Duke chose trespass, but the elements are hard to make out, and it's just hard to square the peg.
So, Your Honor, I may have misunderstood the court's question a moment ago, and I was talking about the 2024 cost order at issue here, and I think that's something certainly Judge Poovey was within his discretion to resolve and make those findings a fact because it was a motion and that's permitted under the Rules of Evidence. As far as the summary judgment motion, of course, that would be governed by Rule 56, which the court can, if there's no genuine issue of material fact, resolve as a matter of law, and I think that's what Judge Poovey concluded and what the Supreme Court affirmed. Lastly, I'd like to talk about the arguments we've heard that the Kisers...
Judge Poovey, I think you and I have a different understanding of what the scope of what the Supreme Court did. They determined the issue as to whether or not Duke could approve docs as to third parties, and by relation, presumably the Kisers as well. But the wall piece was not, the removal of the wall piece, the trespass, whether or not Duke actually had the right to remove the wall was not decided by the Supreme Court.
The Kisers never perfected an appeal on that issue from the 2018 order that Judge Poovey entered. And the Supreme Court noted, if you read the opinion, it noted that that had occurred and that that particular order was not in front of it. We've heard some arguments made in the briefs and this morning that there was a problem with the user agreement, a problem with the application fees, and that effectively the Kisers didn't have a real meaningful opportunity to do the work themselves. So I'd like to address that for a moment. First of all, again, like some of the other issues that are being raised, the objections to the user agreement, objections to the application fee were never properly preserved below. Because those, Rule 10 of the appellate rules requires a party, if you want to appeal an issue, you have to present it to the trial court and obtain a ruling on the issue from the trial court. But that didn't happen with respect to these particular issues. And I think the chronology here is important, so bear with me as I walk through it. So the trial court's order and judgment entered in August 22, 2018, which required the Kisers to remove the wall, submit a completed application, and comply with some other conditions. Even before that order was entered, The Kaisers had the user agreement that Mr. Redding alluded to this morning. It's on page 173 of the record. And they knew about the process, and they never objected to Judge Poovey prior to entry of that August 2018 order about these particular topics. Likewise, they didn't make any objection or seek any ruling from the trial court in 2019 prior to Judge Poovey's November 15, 2019 enforcement order, which noted that the Kaisers had not complied with the prior order to remove the wall, had prevented Duke from entering their property to exercise the self-help remedy, and that it specifically noted, and I'll quote from the 2019 order, that the Kaisers did not, quote, raise any issue with or objection to the excavation permit application and agreement, including all of its associated documents and materials prior to the entry of the 2018 order. So, having not preserved those issues, they're not properly before the court. They weren't raised until the 2024 hearing that led to the order we're here about today. But even if those arguments had been properly preserved, they don't have any merit. I think the record reflects that the Kaisers had ample time, something like 8 months, to comply with the trial court's 2018 order and judgment to submit the required complete application for the excavation permit, and they chose not to do that. The only thing they ever did was submit a partial application that was incomplete, and they didn't comply with all the requirements that have to be met to do this kind of work at the lake. Requirements which, by the way, are driven by Duke's FERC license, and that Duke itself has to comply with when it does work at the lake. It has to pull a permit and comply with that permit if it wants to do this sort of thing. It was frankly the Kaisers' obstinate refusal to comply with the trial court's orders that necessitated the self-help remedy that Duke employed here. And having directly caused that result, we would submit that the Kaisers cannot now complain about it in this court. As many cases have held, we cite those in our brief at page 35. Lastly, I'll address briefly the argument that was made in the briefs that Mrs. Kiser should not have been a party to the order here. Mrs. Kiser was a party to this case from the beginning, represented by the same counsel as Mr. Kiser, participated through counsel at all phases of the case. And this argument, likewise, was not one that was ever made to the trial court. It's not properly before this court, but in any event, there's no merit to the argument. In conclusion, I would just reiterate that this is not a situation Duke takes any pleasure in pursuing a homeowner on Lake Norman over an issue like this. But as the FERC licensee, Duke has responsibilities to maintain the lake, and that ultimately benefits all of the ratepayers that use Duke's power. Unfortunately, in this circumstance, that required litigation, which was unnecessarily prolonged by the Kaisers' refusal to comply with the trial court's orders. And I think the record reflects that Judge Poovey was well within his discretion in awarding the costs that the Duke had incurred in removing the wall, and that the appeal is not properly before the court today. So,
Counsel, my last question, in the affidavits that were submitted as far as dealing with the cost, I was looking for, I know it's probably in here. Was there any determination by the affidavits from Duke that substantiated why the water removal on the barges was used versus coming across the land and using that route? Was there a discussion in the affidavits as to why that decision was made?
Yeah, I think, Your Honor, the affidavits do speak to that, the Kaisers' refusal to permit Duke to access the property.
Is that documented in the record?
I believe that's in,
affidavits?
Ms. Alvarez will keep me honest, I think that's in Chad Broadway's affidavit.
And explain that facts to me. Did they block the driveway, or what was the impediment that prevented Duke from coming across the property?
Your Honor, if I may, I'll just find it here real quick.
Please, I appreciate it.
Your Honor, I'm not finding it immediately. I don't want to spend the time flipping through the record here, but I'm confident that if you read the materials submitted in connection with Duke's application for fees in 2020, it's set forth in the motion and the supporting affidavits, they address the fact that the Kisers basically told Duke's personnel not to enter their property.
And understood, but I just didn't see anything where there was any physical impediment erected or
I don't think that anything of that nature.
Extended. So,
Yeah.
so I'm trying to get, because ultimately that does go to some determination, because the court did read the affidavits. And so in getting to a determination of why the land versus water access was exercised, you know, that is ultimately, regardless of whether there's a valid appeal here or not, is part of the determination of what I think we have to make sure we flush out here.
And the easement itself gives Duke the right to ingress and egress over the lands of the Kisers.
Regardless.
Your Honor, I think that's right, and I think there's no. We're not saying there was some kind of physical wall erected, but there's also an element of this where, and I think Judge Poobie recognized this. Duke's not looking to pick a fight here. It's trying to get the work done, and if you have
a little too late for that, though.
Yeah,
Well,
Duke's the plaintiff.
Yeah.
But Your Honor,
because here's what it comes down to. Driving across the land, $10,000, hypothetically. Barge, $100,000. I think there is something just to be flushed out to see, you know, what was that determination and what went into that decision when this easement and land access has been protected, perfected, and maintained for that very reason. So if Duke is going to forego exercising this thing that they have fought very hard to maintain and protect and exercise, why was the decision and determination used to use the water access versus that thing that they hold very valuable? And that is something that I have not really been able to kind of see in the record, but I think it's very important.
Your Honor, I think that, if I may, I see I'm over time.
We stole about 2 minutes.
Yeah.
I mean,
your
just
time while
respond
you're
briefly.
You're definitely entitled.
I do think that is reflected in the affidavits Duke submitted in support of its cost motion, and that just given the nature of the relationship and what had transpired, this was how Duke determined it needed to get the work done. And Judge Poobie found that was reasonable, and we'd submit that was within his discretion to do so. If I may answer Judge Carpenter's question from a moment ago as well, I would cite you to page 136 of the record, paragraph 23, which refers to the Whitaker affidavit, which is also in the record, paragraph 36 of the Whitaker affidavit that was submitted in connection with summary judgment motion that talks about the Kisers preventing Duke personnel from entering their property. So,
Thank you.
thank you.
Anything else to wrap up?
We would just ask again, Your Honor, that the court dismiss the appeal, or if it does not, that it affirm Judge Poobie's order.
Very good. Thank you. Mr. Wright, you got 4 minutes and 34 seconds.
Thank you. I go directly to 253. That is 253 in the record. That is Whitaker's affidavit. What paragraph 36 says, on September 11th, 2019, Mr. Kiser contacted me and stated that neither Duke Energy, Lake Services, nor any contractor was allowed to access his property under any circumstances. So it was a phone call, and it was done at my instruction because we were still arguing through counsel about whether or not the order required him to sign the user agreement. The ultimate enforcement order is 2 months later. At no time after that enforcement order did either Kiser or myself on his behalf tell Duke they couldn't enter his land, and as the court has pointed out, they had the absolute right to do so through their easement. I wanted to go back to the questions the court asked me about whether or not Kiser had any interest in the land afterwards, and it's at record 288, and this is the underlying summary judgment.
Repeat that.
Record 288.
Okay.
288, paragraph C, and this is the court quieting title in the name of the third parties. In the order, it says the Kiser submerged tract, which is the 280, is hereby quieted in the names of the Schmitz, the Shepherds, and the property owners, and their respective heirs, successors, and assigns. Paragraph D, defendants and their successors in interest are ousted.
Was there a quiet title action brought?
Yes, by the third parties. Defendants and their successors in interest are ousted from any real property interest or claim or trespass for rents in the lots of the Smiths, et cetera. That's why I say, Your Honor, by upholding Judge Poovy's underlying summary judgment, the Kisers were ousted and had absolutely no property interest. It went from being forced to accommodate the third parties on the land through the Duke easement to you have no interest whatsoever, completely divested. So I hope that answers the court's question. It's not in the Supreme Court holding, I agree, but that's the practical matter by upholding Judge Poovy's underlying summary judgment. Now, as to the contention that I've never argued Judge Poovy's comments during the hearing, I didn't have to because it's on page 32 of Appellee's brief. They brought it up. I'm just arguing what's in their brief. So they specifically cite on page 32 of the brief the very passage that I read to the court that my friend says we never argued it. If he's going to bring it up in his brief, I have the right to respond to it and point it out to the court, put it into context. As to not having raised the idea that the final order that we're appealing from was a substantial, comes under appeal under a substantial right, well, there would be no reason to do that because it's a final order. The only time substantial right matters is if it's an interlocutory order. And I think the court seems to agree there's only one final order in this case, and it's the last order. It's the 2024 order that we're taking this appeal in. So there's no real reason for me to have raised it in my initial brief if it's the last order. I don't really know how to argue against the contention that the $72,000 court cost award / judgment can't be appealed or reviewed in any way. I mean, just as a matter of fundamental fairness and substantial due process, it has to be appealed some way. As a matter of fact, it's a final order. It has to be. And under GS 12277A, an order that discontinues the action is a final order, and a direct appeal to the Court of Appeals lies therefrom. So, you know, we have the right to appeal there. So the fact that we can't appeal it is kind of crazy. The contention that I didn't preserve my arguments with regard to the fee and the user agreement is belied by the transcript on page 19, starting on line 21 and going to 2017. I reiterated the very argument to Judge Poovey in that hearing on the 2024 order that I had made several orders before. Same exact argument, and my friend was not present in court that day and doesn't know that, but I've been making that argument from the very start. My client does not have to sign that user agreement. He cannot be forced to waive his rights and impair his counterclaim. As to the evidentiary hearing, I certainly did object because it wasn't set for an evidentiary hearing, and if you're going to bring in witnesses and suddenly say they're going to testify, I have to object. I don't even know what they're going to say. I don't even have my witnesses there. Finally, if the partial summary judgment was on liability only and it left damages to be determined and there's countervailing evidence by affidavit, then it can't be granted by way of summary judgment. It can't be because there's a disputed issue of material fact. There had to be a hearing if the court was going to do that. And the court simply the judge supplanted his own observations and beliefs about Kiser's character to decide that if Duke had done what it had the absolute legal right to do through its easement, if it had done that, it would be a subsequent lawsuit filed by Mr. Kiser because that's the kind of guy he is. That's abuse of discretion, and the court should grant some relief we pray for. Thank you.
Thank you both for a well-argued case. And we will take our advisement. Mr. Clerk, if you'll adjourn us.
All rise. This session of the North Carolina Court of Appeals is adjourned.
Well done. Great to meet you.
Nice to meet you.
Nice to see you again.